required to post anything. So long as you're showing up for court and abiding by the bond conditions, then it shouldn't be a problem. Okay?
Okay.
Okay. So, Attorney Moten, did you want to add anything?
No, thank you.
Okay. Then, Ms. DeGraffenreid, you are free to sign out of Zoom.
Okay. I have a question for Ms. Moulton. Is there a...
We will give you a call. Let's not put it on the record.
Okay, perfect. Sorry. That's what I was going to ask. Thank you. All right. Well, thank you guys. Have a great day.
Okay. Thank you. You too.
Thank you, man.
Okay. Now calling case numbers 23W000748A and B, 23W002101, 23W003414A, and 23W001067. These are all the Township of Ypsilanti versus DeMonte Horton. Can you please unmute and state your name for the record? To the phone number ending in 4080, please hit *6 to unmute and tell me who you are. If you are in fact the interpreter, I would be talking to you, so *6 to unmute. Attorney Dadush, you spoke with Ms. Whittaker as well, correct?
Yes, I did.
Okay, thank you. Now calling case numbers 21S00114 and 21S00345. These are the State of Michigan versus Bridget Renee Whittaker. Can I have appearances for the record, please?
Good morning, everyone. Ken Dadush on behalf of Miss Whittaker, and yeah, that's it. It's an older case.
Okay, Ms. Whittaker, can you please knock on the door and have them unmute you again? Okay, and state your name for the record, please, ma'am.
How you doing this morning? My name is Bridget Renee Whittaker.
Okay, thank you. So today is the date and time set for arraignments in these matters. What I am seeing is that bench warrants issued for your arrest back on September 5th of 2024. And that was after you failed to appear for a court date in front of Judge Washington. That was to be a, I believe, violation of probation hearing, September 5th, or you were to provide proof that you were in treatment. So basically on September 5th, you were either to be at the court in person or you were to have been in treatment. So you were not there, and we had no indication that you were in treatment. And so bench warrants issued for your arrest. Attorney Dadush?
Magistrate Braley, Miss Whittaker indicated to me that she was in fact in treatment. I do believe her attorney at the time, Miss White, had been transitioning from different courtrooms, if I'm correct. Maybe it slipped through the cracks because of that, which is our fault. Miss Whittaker does have proof. She was at Sacred Heart. She was testing there, and even I believe the judge had told her at the time that if she doesn't show up for her next court date, that would be good because that would mean that she is in treatment, in which she was. Once she's released, she for sure is able to provide us with that documentation. She's not sure why, when she talked to the people at Sacred Heart, they indicated that they would be notifying the court that she's in treatment, but she doesn't understand why it would never sense. But she was in treatment at the time.
Okay. So Attorney Dadush, at this time, the judge has, back on September 5th of last year, ordered that bond be denied for both of these. And my concern is that I don't have any sort of indication that there was treatment.
could we reach out to him? I do have paperwork. I got all my credentials to say that I was there. Even my kids was in the facility with me because I'm a single parent. I had nobody to watch them. So they was there as well. I don't know why they didn't, reach out. When I was in there, we reached out over to the courts to let them know. They just said make sure that they send that paperwork over. I don't know why the lady didn't send it, but you can have her call right now. It's on record, and I have proof and paperwork that I could bring back up here today to prove to y'all that yes, I was in fact in there, and I passed all my drug screens and alcohol tests and everything. I have all that paperwork, and I sent it through email to somebody to the courthouse, and then I had my mother fax it over as well to whatever attorney was taking Miss White place during that moment, because I had found out that she wasn't even there. And they told me they was gonna lift that because she told me that I had a warrant, and she told me, she was gonna lift that. She was like, well, nobody reached out to us, so I sent her over all my paperwork. I have proof of everything. I wouldn't sit here and tell a story. Y'all could call Sacred Heart right now while I'm sitting in this chair. I have proof of everything that I'm telling y'all.
Attorney Deduce, do you have any sort of release of information for Sacred Heart?
I don't see any indication of that on the file. I could reach out to the 14B attorneys real quick and see if anyone has that, or if it was sent to any of the attorneys. Even if it was sent to Miss White, and forward that to the court. I did reach out to the 14B attorneys. They're responding. Hopefully one of them has that.
Would you be able to reach out to Sacred Heart? Because they know me very well. If you,
I mean, I could, but just for purposes of, I believe, speed, the attorneys will be quicker than Sacred Heart right now to be able to provide that to Magistrate Braley. Did you email it, or did your mom email it to us?
my mom faxed it from her job from the University of Michigan, and I emailed it from my email.
Okay.
I did both because I didn't know which one was going to get to her quick. And then the lady told me that she has them on her desk and she was going to have her give me a call. When I talked back to her, she told me she was going to go over my paperwork and call me back with an update. And I haven't heard from her. So I'm thinking, I was in the clear of everything.
So I do see a letter dated August 22nd from Sacred Heart that indicates that you were scheduled for an intake on August 30th of last year.
And I went in, and they scheduled me for September 4th to go in. And the judge told me if she don't see me on the 5th, that's a good thing because she knows that I'm in there. If I don't show up to court, that means that I'm not in treatment. If I do show up, you get what I'm saying?
Yes. So I think the issue is that I don't appear to have anything else from Sacred Heart after that August letter. Okay.
Right.
So here, just give me a moment, please. Attorney Deduce, how did your client come to be in custody today?
I believe it was a traffic stop, correct? Miss-
I came in contact with the police in Detroit. No, it was not a traffic stop.
Is anything else holding your client?
Don't believe so. Let me see real quick.
Okay. Do you know if there were any new charges as a result
Of the
whatever happened in Detroit?
I only see 2 misdemeanors. Which are these, the one that,
Okay.
yeah, there's nothing holding her, it seems, from any other counties.
Okay. So what I am going to do is this. And this is because I am finding what you say to be credible. All right. So I am going to grant personal recognizance bonds in these matters. They're going to be $50,000 personal recognizance bonds. Okay. You're not required to post, but if you don't show up for your next date, I mean, first off, you your bond will likely be revoked, but at a minimum, your bond on each of these will be $50,000. Okay? I am adjourning this arraignment to July 8th. So that's next Tuesday at 9 a.m.
Okay.
Before you come back on Tuesday,
Mhm.
I want to see the documentation that you're talking about.
Thank
Okay?
you.
I want it in the files, so I don't care. Fax it, email it, carrier
Now, can I bring it straight here? Yeah, I'd rather, so I know that, or however, I could bring all that. I could bring
Yes,
it.
so that we can see that you were in treatment and what the dates were.
Okay.
So once I see you, I want that documentation before your next court date. Like I said, I'm adjourning the arraignment to July 8th. Okay, so you're gonna
Next
come back
Tuesday.
in front of me over Zoom, July 8th, 9 a.m. Okay, and then once I've seen that documentation, then I can set you for a hearing in front of the judge.
Okay.
Okay, and that will be the continued violation of probation hearing that you would have had anyway. Okay?
Okay.
So, all right.
Thank you, Your Honor.
Thank you.
Can I
So,
just confirm again, just because I want to make sure that she's sending the proof, the phone number 8234, is that still your phone number? And I have your most recent, okay.
Yes, ma'am. And do you want my email address as well?
I have your email
we're
address.
on YouTube.
Yeah.
Huh?
We're on YouTube, but I have your email address and we've talked about your number and your address. I will reach out to you just to make sure that you are having everything sent to the correct person before your next court date.
Okay. Okay.
Thank you so much, Magistrate Braley.
You are welcome.
Thank you
and-
so much. Thank you. And I won't, trust me. Thank you for believing what I say, because I'm gonna give you all that information. And sorry about the misunderstanding, because I don't know what went on.
Yeah. Certainly things happen. Like I said, just, I want to see you back July 8th.
I'll be there.
Okay, okay then. I will see you then with the documentation. Okay, and we will go from there. All right?
Okay. Is it at 9 a.m. as well?
Yes,
Okay. Thank you.
yes. So Tuesday, 9 in the morning.
Okay.
Okay? Then you are free to go to the door and tell the jail that you're finished, okay?
All right. Thank you.
Thank you. Okay, and once again, person on the phone number ending in 4080, I sent you a prompt to unmute. Please hit *6 to do so.
All right, let's talk about that. The hearing for Bridget Renee Whittaker in front of Magistrate Hillary Braley was an emotional one, but not in the dramatic, yelling in court kind of way. It was emotional because it showcased something we don't always get to see in the courtroom: belief in people when the paperwork doesn't quite keep up. Whittaker had a bench warrant issued last September for missing a court date tied to a probation violation specifically. She was supposed to either show up in court or provide proof she was in treatment. She didn't show up, and the court had no documentation, so the bench warrant was issued. But according to both her and her attorney, she wasn't skipping court. She was exactly where the judge had told her to be, in treatment at Sacred Heart. Now, this was no vague excuse. Whittaker showed up on Zoom with receipts literally. She told the court she had documentation, test results, and even a letter from Sacred Heart. She'd faxed it, emailed it. Her mom had faxed it again. She even named the specific employee, who said she'd put the papers on the judge's desk. And you could hear it in her voice. She wasn't evasive. She was frustrated. She thought she'd done everything right, but somewhere in the shuffle, maybe a missed email, maybe a dropped bullet didn't get logged. That happens more than we like to admit. And Braley, to her credit, didn't dismiss the story or demand more from someone who was already, clearly, doing her best. Instead, Magistrate Braley did something both firm and fair. She listened, she asked good follow-up questions. She verified that Whittaker wasn't being held on any other charges. And then she did what any reasonable person should when someone sits down, lays out their story, and offers proof. She gave her a second chance. Braley reinstated bond at $50,000 personal recognizance, meaning no payment required. But a very clear warning: miss the next date, and it's a whole different story. She adjourned the hearing to July 8th, requested Whittaker to submit that documentation properly this time, and reassured her that once it's in, they'll set the next hearing with a clean slate. That was also a subtle, meaningful moment when Whittaker thanked Braley directly for believing her. "I won't let you down," she said. It wasn't theater, it was accountability wrapped in gratitude. This wasn't just a procedural hearing, it was a reminder that while the justice system has rules, it also requires human judgment to interpret those rules when life doesn't follow a clean checklist. Attorney Dedouche handled her role calmly, helped fill in the context, and supported her client's credibility. No theatrics, just steady advocacy. And Braley, she stayed steady, even as the hearing had some internet hiccups, case confusion, and crosstalk. It was a Zoom courtroom, after all, never without a little chaos. But through it all, the vibe remained calm, patient, and respectful. So while this wasn't the kind of hearing that goes viral, it might be one of the more important ones. Because sometimes, the win isn't the verdict, it's being heard, taken seriously, and given a path forward. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.